Focus of my presentation is the relationship of names, especially trade names, and trademarks. And I hope you will see from the slide that the title is an unbalanced equation. And I'm going to explain that, I hope, but before doing so, I'll make a few introductory points. First of all, as you know, trade names in general have their own registers in many member states, though not all trade names are registered. Many member states also have a mechanism whereby company names can be dealt with via a dispute process that's not related to trademarks. But nonetheless, the law has to accommodate some relationship between trademarks and trade names. And the two issues where this comes up, most importantly in sort of litigation, are first of all when the trade name is an earlier right and therefore can be deployed against registration of an EU trademark or a UK or a national trademark, but also where the trade name is the subject of an infringement action. And one would expect the law to take a consistent approach between those two sides of the equation, so to speak, and I will suggest that the latest reforms that came into force last year do not do that, for reasons, again, I'll explain. So, hold on. This is the one, isn't it? Yeah. So this is an outline of roadmap of where I'm going. I'll start with a brief analysis of Article 8.4 of the regulation, which allows the deployment of a trade name to be used against registration of an EU trademark. And I'll touch upon two cases. First of all, the Forge de Laguiole. Is that a good pronunciation? Someone will correct me if that's wrong. Forge de Laguiole. And also an older case, Ferrucci, which is a case about personal names. And I just wanted to explore those two cases so that you could have a feel for how earlier names are, whether they be personal names or trade names, can be deployed to prevent the registration or invalidate the registration of a trademark. And then I wanted to look at the own name or the trade name defense as it was originally formulated in the law, explained in the Anheuser-Busch case by the Grand Chamber, and look at how that has played out in a number of UK cases where the defense has been quite important. And then finally to look at the reforms that were made to the law. One could say rather in a rather cursory way, the defense was simply taken away. And also let you know about a case, Sky versus Skykick, which is potentially going to be exploring this issue a bit further. So, trade names as earlier rights. You'll all be very familiar with this provision. This is the basic provision that applies and routinely applied by the office. It's a tricky provision, actually. It's a provision which refers to, obviously, a non-registered trademark or another sign used in the course of trade. There are other requirements. It must be more than local significance. Rights have to be acquired prior to the UTM. It must give rise to a right to prevent, and so on and so forth. And actually, if you look at the cases on this provision, they've been pretty inconsistent. And you can see why, because what's happened here is that the office is dealing with a wide range of mixed laws from member states relating to the protection of names of various kinds. And ultimately, the General Court, the office, are applying union law and sort of taking it on faith that the description of national law that's being presented to them is correct, adequate, full, up to date, and so on. So it is quite tricky. I heard one of the General Court judges describe this provision as a bridge between national law and EU law. And that's right, but the bridge can be sometimes very difficult to cross because you've got the national advocate, well versed in Italian or UK law, telling the General Court or the no doubt in the office in written submissions, what the law is, and the tribunal may not be up to speed. And of course, just to give you an idea about the range of laws that can come up in this way, in the UK there's a case called Tilde Riceland, which was decided by the General Court, in which the UK earlier right was a right of extended form passing off, which is a right that doesn't really exist in many other member states. And of course the office struggled with understanding that right to begin with. The General Court got there in the end. Extended form passing off protects not just a distinctive sign of a single trader, but a category. So for example, in that case, the category was basmati rice, and so someone couldn't register the name Basmali in the light of this descriptive, you could say descriptive title, but one that was protected under extended form passing off. So it can lead to quite some difficulties in trying to understand and apply the national law. So the case I wanted to just look at, which is fairly recent, is the Forges de Laguiole case, and which is a further example of a sort of local exoticism that the office and General Court were sort of struggling with. Some of you may be familiar with this brand. It's a case about names, about knives. And Mr. Chaznar is the proprietor of the EU, was the proprietor, or is still the proprietor actually, the proprietor of the EU word mark Laguiole, which was applied for in 2001 and registered in 2005. And there was a declaration of invalidity by, based on an earlier business name, Forges de Laguiole, which was used by that company for the manufacture and sale of cutlery articles, scissors, gift articles, and souvenirs. And you can see the French national provision there. A sign may not be adopted as a trademark if it interferes with prior rights, in particular a business name or corporate name, if there's a likelihood of confusion. So far, so good. We understand the concept of likelihood of confusion. We understand that it could interfere with prior rights, etc., etc. But where the difficulty was that there was a question under French law whether the protection applied not just to the goods and services in which the company actually traded, but all of those listed in the objects of association of the company. So, you know, it's typical for a company, I don't know, I haven't looked at the French company register, but the UK company register typically contains companies with a long list of objects and activities that it's sort of being registered for. We really have no relationship to, they're nothing more than a speculation or a guess as to what the company could potentially trade in the future. So the question in this case was protection, did protection cover all of the objects of the company, or did it only cover those in which they could establish trade? So actually, just as a sort of side issue, an interesting procedural point came up in this case as well, because what had happened was that the Board of Appeal took the view that the protection extended to all of the business activities covered by the objects. But then, after the Board of Appeal decision, but before the General Court decision, there was a new judgment from the Cour de Cassation which held that the business name protection in France only covered business activities actually pursued by the company. So it sort of narrowed it quite significantly. But the argument of the applicant was that the General Court was not entitled to take it into account because effectively, as you know, the General Court reviews the legality of the Board of Appeal decision on the facts and law as before it and shouldn't really be taking into account things like that. But the just as a side issue, the ECJ essentially said that under Article 8.4 cases specifically, there is a wider power to take into account decisions of the national courts that post-date the date of the Board of Appeal decision. And this was based upon the, shall we say, proactive powers that the court has in Article 8.4 cases to find out what is the national law, not to have to just take it on faith what the national law is. And so this was a bit of a carve-out. It's important to recognize this does not, as far as I can read, represent a complete departure from the review of legality principle. It seems to be that it is only in Article 8.4 cases. that this is applicable. So that's that case. I wanted to just mention also personal names as earlier rights. So we filled in the first part of the equation, the trade name being used to prevent later trademarks. What about personal names? Can they be used to prevent trademarks? Well, there's a ground of invalidity, Article 53(2). A community trademark should also be declared invalid on application to the office or on the basis of a counterclaim, in that the use of the trademark may be prohibited pursuant to another earlier right. And you'll know that this has a list of other earlier rights, a right of personal portrayal, a copyright, an industrial right, but also a right to a name. And what does this protect, is the question. Does it protect only personal names, used personally in a personal context, or does it protect trading names, personal names used in a trading context? Elio Fiorucci was a famous fashion designer in the 70s, now deceased. And the facts of the case are a little bit surprising, actually. So Ferrucci SPA was a company he set up in the 1970s, and then it sold all of its trademarks and creative assets to effectively a party I'll call the assignee, along with numerous trademarks containing the element Ferrucci. And then that assignee company applied for and got an EU trademark for Elio Fiorucci. And then Mr. Ferrucci turned around and sought to have that mark declared invalid on the basis that it was his own name. And he relied upon Article 8.3 of the Italian Industrial Property Code, CPI in the law reports it's called, which said that if they're well known, the following may be registered as a trademark by the proprietor or with the consent of the proprietor, personal names. So it said that personal names, if they're well known, can be registered with the consent of the proprietor. And Mr. Ferrucci argued that he'd not given his consent. Now, I have to say I didn't quite understand how this argument got off the ground, because there was an assignment. I guess it was because it was Ferrucci that he'd sold, not Elio Fiorucci. But it isn't clear from the report that that's right. Anyway, the significance for our purposes is it ended up on appeal to the CJEU, and the assignee company argued that this provision, right to a name, effectively was intended to protect only rights of personality, not commercially exploited names. And by contrast, the Italian provision was aimed at commercial exploitations. And the CJEU held that it was wrong on both counts. And most importantly for our purposes, the CJEU said in relation to the right to a name, that if you look at the provisions there, right to copyright and so on, that this is a non-exhaustive list of rights that can be commercially exploited, but don't have to be, and should not be and may not be confined to only the personal context. In other words, you can use a personal right that has been exploited commercially under this provision as well. And for reasons I'll come to, that's a very significant point. So we have personal names being given a broad scope to prevent later trademarks, and they're not being treated as being confined to use in a personal context. You might think that this is simply a way for somebody, a famous person who happens to be famous, who doesn't commercially exploit their name, to prevent a trademark being registered. Let's say the son or daughter of a famous celebrity, that Victoria Beckham's daughters, I think, have just been registered as, or kids have just been registered as trademarks. So it might be said that this is a way to prevent other people from doing that. But the message from this case is that it includes that, but is not confined to that. So we then turn to the own name defense. So I'm now going to look at the other side of the equation. What happens, we've been looking at how trade names are used to prevent marks. Now, what about how marks are used to prevent trade names? How does the law deal with this? Now, you'll remember that the old CTMR, I'll call it that, Article 12A and the old Trademark Directive equivalent, stated that community marks shan't entitle the proprietor to prohibit a third party from using in the course of trade his own name or address. His own name or address. The use of the word his was slightly concerning if you were going to extend it to non-natural persons, but in any event, that's what the provision said. And missing from that slide, of course, is what's called the honest practices proviso. That defense is and was subject to a requirement that the use be in accordance with honest practices in industrial and commercial matters. And there's plenty of case law on that, Celine and other cases. So the question was, did this cover natural persons, or was it confined to natural persons? Did it include also trading entities? And as you probably remember, the Grand Chamber in the Anheuser-Busch case is well known for having, in effect, construed the words his own name to apply to non-natural persons as well as companies. Just to remind you of the facts of that case, Anheuser-Busch sought an order preventing Budvar, the Czech brewer, from using in Finland the trade names Budoviki Budvar, Budweiser National Enterprise, Enterprise Nationale Budvar National Corporation, and so on the basis that those names were liable to be confused with Anheuser-Busch's marks. And the question for the court was, as I say, whether that covered that sort of use. And a lot of people remember the case as having basically just decided that it covers trade names and having rejected the relevance of a council and commission note, a joint declaration, which had been recorded in the minutes of the council, that the provision only covers natural persons' names. But what's perhaps less remembered is that the Grand Chamber did actually grapple with the policy of why his own name should cover trading entities and not just natural persons. And we can see that in a couple of the quotes that I've put down there. They referred to Article 17 of the TRIPS agreement, which is headed exceptions. Members may provide limited exceptions to the rights covered by a trademark, such as fair use of descriptive terms, provided that such exceptions take account of the legitimate interests of the owner of the trademarks and of third parties. So what that is saying is you can have limited exceptions, provided they strike a balance, and the approach should strike that balance. And then they, perhaps most importantly, said at paragraph 85, the exceptions provided for in Article 17 of TRIPS are intended, inter alia, to enable a third party to use a sign which is identical or similar to a trademark to indicate his trade name, provided that such use is in accordance with honest practices. So it's basically saying that Article 17 has that intention behind it. Now, the only counter-argument that was run in that case, I mean, you know, obviously we're only going on what's written in the report and in the opinion, but the principal argument seemed to be that there was a council and commission joint declaration which confined it to natural persons. And the court said, well, that has no legal significance. But what it didn't do really in that case, I suppose, is deal with the counter-arguments, if they were made, about why natural persons deserved such a defense and trading persons didn't. Now, I just wanted to, before I look at the reform of this, just give you a couple of examples in national law where this defense was hugely important. It was the decisive point in the case, in big commercial litigation. And actually, one of the reasons for mentioning this is I'd also be interested, given the range of attendees we have here, to understand if anyone has any sort of similar experience from their own jurisdictions. But this is a case, actually, I was for the unsuccessful claimant, BDO, the firm, who were a firm of accountants and financial consultants and so on, much wider than that now. And they had a Class 36 registration covering, as you can imagine, a huge number of services to do with money and advice and that sort of thing. The defendant was Banco de Oro, a Philippine bank that operated under the acronym, or the initials BDO, and BDO Unibank. And they had no offices or premises in the UK, but the infringing acts, the allegedly infringing acts were, well, the infringing acts, because they were held to be infringing, were that there were uses of the sign in sort of small grocery shops and so on for Filipino expats in the UK to remit money back home. So there was a little sign in some of these where you'd go to the counter and it'd have BDO on it. And there was some advertising in magazines circulated in the UK. There were no real instances of confusion in the way that that might be understood conventionally. There were no customers of the accountants thinking that the bank came from the accountants or was linked to them in some way. There was confusion in the other direction. There were some Filipinos who had looked online, Googled BDO, found the offices of the accountants and called the switchboard to try and send money. There's wrong way round confusion, as it's sometimes called. And the judge, Mr. Justice Arnold, I'm sure most of you know well, held that the marks were similar, or they're almost identical. This was there was an EUTM, by the way, and there were similar services, not identical services, and therefore he held that there was essentially a likelihood of confusion. And this is a classic case, in a sense, because you've got what might be called a paper-based infringement, where you've got a very wide specification that is covering the defendant's goods, no genuine conflict in the marketplace. I say, arguably, I was acting for the claimant, so I was saying there was a conflict. But let's just say that it was at least arguable that there wasn't. No actual instances of confusion, no free riding, no competition, arguably. And how was it resolved? It was resolved in favor of the bank on the basis of use of its own name in accordance with honest practices in industrial and commercial matters. So it was a very important and decisive defense in that case. Another one more recently that went to the Court of Appeal is the ASOS and ASOS case. Well, you can sort of see what's going to happen here, can't you? Again, this was essentially a paper-based notional trademark infringement case where the ASOS company, Double S, had a trademark registration for clothing, Class 25, and I think I may not be recalling the details of the case completely accurately, but in essence, there was a paper-based infringement in the sense that the goods of ASOS, which is an online fashion retailer, fell within the specification of the claimants, or else were very similar to that. The marks are obviously quite similar. But there was no confusion, no overlap, because basically ASOS, the claimant, was what was called a hardcore bicycle clothing manufacturer, very specialized, and the defendant was a fashion retailer. And so the Court of Appeal held that there was infringement, but there was an own name defense that was applicable. And the factors that it took into account were these. The parties had adopted their names independently. Although the defendants hadn't conducted a trademark search, had it done so, it wouldn't have revealed very much, other than that a business called ASSOS was directed to cycling gear. Over the years, the parties had continued to develop and expand their trade side by side. There was no confusion in practice, no real likelihood of it occurring in the future, and no competition and no real commercial clash. And so this was an important defense, and this went to the Court of Appeal. Now, the problem with what happened next was really very much, I would say, under the radar. This defense was removed, and I would suggest it was removed in a rather draconian way, without any real analysis, any impact assessment. And what seems to be the case is that a lot of people who would not have been infringing prior to March 2016 are now infringing. Among them, these two. But I imagine many others in many member states. There's no transitional provisions, no grandfathering, so if you were using before, you didn't get to continue use, provided you don't change. I mean, there are other arguments you could potentially run, Budweiser-type arguments about honest concurrent use and that sort of thing. But what's happened here is that a large number of businesses in member states who would have been able to avail themselves of an honest practices, honest use of own trade name, non-competition defense, are no longer able to do so. And you can see what they did is they basically just added the words, where that party is a natural person, to both the directive and regulation. In terms of implementation, the regulation came into force in March 2016. The directive has to be transposed in national law by 2019, sometime like that. So it's all happening fairly soon. Now, I just wanted to, because this is the ERA, I wanted to look back at how we got there and what sort of analysis and scrutiny was given to this to decide to remove it. You're all very familiar, I'm sure, with the Max Planck Institute and, most importantly in trademarks, the Max Planck Report, which, as you know, was the trademark study commissioned by the EU to examine how trademark law was doing. And the answer was it was doing actually pretty well. It was doing, well, it hadn't done a bad job. There were a few wrinkles, there were a few things that needed to be sorted out. Graphical representation needed to be sorted out. There was quite a lot of codification of ECJ jurisprudence. Not sure why that was necessary, given that the case law says what it said. But anyway, it made various recommendations for reform, and one of these recommendations was that the trade name defense, as I'll call it, should be abolished. So it should be confined to natural persons. And as we've seen, that was what was followed. Now, I don't want to criticize the Max Planck Report generally. I have to say it's one of my first ports of call whenever I'm trying to analyze the law of trademarks. If I've got a student or a pupil, as they call it in the UK, who wants to understand trademarks law, it's a pretty good analysis of where we are, or at least were when the report was written. But where I take issue with it is that I would suggest it's overly academic in nature and didn't actually conduct empirical assessment into some of the reforms made, and unduly focused on doctrinal neatness and academic theory. I mean, for example, even though if you look at the report, it says that it's based on a survey of users, statements of user organizations, information from national officers, legal analysis, and economic analysis, none of that related, for example, to the trade name defense. There was just simply nothing. Now, you know, you'd expect there to be some assessment of how businesses would have to cope with this defense being abolished. And by the way, this was also coupled with an amendment to the list of infringing acts in both the directive and the regulation to make it clear that a trade name could infringe. I mean, we knew that anyway from Celine, but that was put in there. Let me just show you the justification that's actually in the report. So these are, I've taken out the essential points. This is a summary. I don't think I've missed anything of any consequence. So the first point they say is that there'd been an overly broad interpretation by the ECJ. That's a reference to Budweiser, to the Anheuser-Busch case. But most importantly, it's just said to be overly broad. There was no engagement with the policy of what Article 17 trips or striking a balance or any of that. Or if you're going to give trade names the right to protect, then you should also take the same approach when it comes to infringement. They just said that was the ECJ had taken an overbroad approach. They did then say that allowing trade names to be invoked as a defense was a way, created unequal conditions for trade names and trademarks in case of conflicts, because trade names are regularly granted unrestricted protection against younger trademarks. And we saw a moment ago that you can invoke a trade name to prevent a trademark, so you can sort of see where they're coming from. But here we're trying to ascertain why you should allow personal names to be invoked as a defense, but not trade names. But we saw in the Ferrucci case that personal names, and even commercially exploited ones, can be invoked to prevent trademarks. So that doesn't seem to be much of a distinction. And the next point is more or less the same one. Thereby, this clashes with a maxim which is well established in the legal tradition of most member states, namely that all types of distinctive signs belong to the same branch of the law, and that conflicts between them should be uniformly resolved on the basis of priority principle. I mean, that seems to be saying it's doctrinally neater to have it restricted to personal names. But I would suggest that's not right, because if you're going to have a neater equation, you're going to say, right, personal names and trade names can be used to prevent trademarks, therefore you can allow these to be invoked as defenses, obviously subject to the honest practices proviso, and everything is a bit more doctrinally neater that way, I would suggest. And the next justification was, I seem to have the next justification is the last bullet point. They actually, and it's it's what gamblers call a bit of a tell, because they said, we don't take a position on whether family or forenames should be protected, or nor do we take any position as to what happens if there's a succession by a business, that personal name is then assigned to a business or partnership or company. In my submission, that sort of gives the game away completely, because that's the problem. A name is just a name. If you look at Fiorucci, he was commercially exploiting that name. Then he assigns it to a company who exploit it. Then he wants to invoke his personal name, which has also been commercially exploited and is treated as a trade name in any event. I mean, some of the most famous names in business were personal names. At what point can they be invoked or not? I mean, I'm thinking of Alexander McQueen, or closer to home, Eden Ravenscroft, which is a robe maker for barristers. So these were real people, but they're businesses. So this distinction between a business and a real person and a natural name is a false one. There seems to be an argument, you can change your business name, but you can't change your real name. Well, you can change your real name, actually, as it happens, but also any newly changed business name will fail on the honest practices proviso. If in the Unibank case, the Filipino bank had only just started trading as BDO, it wouldn't be able to avail itself of the honest practices defense. So these are distinctions which seem to be a little bit artificial. And as I say, the defense can be hugely important, and has been hugely important in these sort of paper-based infringement cases. And most importantly, no consideration of the many businesses who currently had the benefit, or who did have the benefit of that defense and then lost it. So I would say that's a bit of a problem. I would say, and when I say we, it's because it's a point I'm arguing in this case here. So in this case, this is the last slide. It's really just to inform you of a pending case that is going on in the UK courts. Sky, the broadcaster, have a large number of EU trademarks and UK national marks, and they are relying on that mark to prevent Sky Kick, who are a cloud migration data backup company, to prevent the use of the mark. So it's an infringement case. And Sky Kick, my clients have invoked the own name defense in relation to both the EU trademarks and the UK marks. If you just think about that for a moment, there's a slight problem there, because the EU trademark defense, own name defense for trading companies, was abolished in March 2016. So this is now. How can they invoke that? Of course, in relation to the UK marks, there is the UK hasn't yet transposed the provisions, so there's still an own name defense for trading companies in the UK, as there probably is in most other member states. As I understand it, almost no member states have brought in all of the provisions of the directive yet. So how did Skykick consider that it could even run this point? Well, Skykick is contending in that case that the measure to abolish the trading name defense is invalid and should be annulled by the Court of Justice, and brought an application for a pretrial reference on the point. Mr. Justice Burse declined to make that reference and has left it to the trial judge without wishing. I mean, you can read the judgment yourself, but the basic rationale of the judgment is that he considered that there should be a trial in any event on the facts of honest practices, because if that failed, then there would be no need for a reference. Alternatively, the defendants could win on infringement. Skykick's not similar to Sky, and therefore they could win on that. And I think he was unable to reach a firm view as to whether the measure was disproportionate, a breach of fundamental rights, and so on and so forth, which were the Skykick arguments. I'm slightly limited in terms of what I can say about it, just because it's very much a pending case. So I mentioned that as being a last point. But as I say, I'd be very interested to hear from anyone who has any experience in other member states, because it does seem to me quite a large reform, one that potentially turns companies into infringers overnight when they were not prior to that, to have been done without much assessment or any assessment, and really just a little bit of legal analysis. I mean, it's always the way with these measures. If you look at the substantive legal reforms to IP law generally, but let's just focus on the trademarks, the new trademarks directive and the new regulation. The only voices in the room, and the only lobbying voices, are trademark proprietors. So, and everybody thinks it's a jolly good thing that you should have better, longer rights. So, you know, now you can sue in relation to preparatory measures, and your defences have been removed, and your requirements for representation have been relaxed, and you've got a bunch of new marks like certification marks and so on. It all sounds great. It's all really, really great in terms of trademark proprietors. But you have to remember in these cases, particularly if you're a litigator, as I am and Jeffrey is, you know, we see things from the defendant's point of view as well. And we also have to remember that it's not just the defendants aren't just small, irrelevant companies. In the Mayer and ASOS case, ASOS were far bigger than the claimant, and many jobs and many legitimate businesses are at risk. Indeed, in the BDO Unibank case, I think the bank was a large enterprise. So you're not just dealing with small crooks or counterfeiters, and therefore you can get rid of their defenses. And the basic thing with the honest practices proviso was that it was a suitable way for the courts to be able to distinguish between cases of competition and honest competition and cases which were on the wrong side of the line. And I think that is the difficulty, I would say, I have with the reform that was made, and be interested to hear if anyone has any similar experiences from their own member states. Thank you very much.